So I'm here with Alan from the Democracy Fund. Alan and I have both been in the courtroom across the entirety of the proceedings of the past 4 days. And I really want to get your take. I want to share it with our Rebel News audience in terms of what you've observed, what the major takeaways are, and what's important to know. I'll share with you some of my takeaways. The primary theme that I've observed is that the evidence introduced by the prosecution and some of the evidence sought to be introduced by the prosecution is undermining one of its central arguments, as we heard in the opening statement on day one. So the prosecution said the Freedom Convoy was, quote, anything but peaceful. Yet, video after video that was shared as evidence or introduced to become accepted as evidence. And today, for example, we saw this press conference from towards the end of the Freedom Convoy in which Tom Marazzo, who was, let's say, a volunteer of the Freedom Convoy, was speaking in anticipation of this police takedown of the protest. And he was repeatedly calling on supporters to come to Ottawa and be peaceful. He must have used that word 5 times. He regularly emphasized the need for peaceable assembly, and he also maintained that in the event of a police takedown on a physical basis, that the demonstrators would not be violent, they would not resist, and that they would comply with demands.
We're here to talk. Let's find a peaceful resolution to this. I want to go home. I want to go home. But I'm not. I'm not going until I'm no longer needed here. And based on all the support that we have from the people of Canada, I have an incredible amount of support and a lot of people that seem to want me here. And I'm not going home until the job is done. Okay? I am not calling for violence. I'm not expecting you to get into your vehicle, drive here, and create problems, create crimes. Okay, that's not what we're saying. Strength in numbers. We got sent here to send a message. The message isn't getting through. He's not getting it. And I apologize if I'm bashing the guy, but honestly, from my assessment, he's got a 22 caliber mind in a 357 world. Okay? Let's get at a table, for God's sakes. Enough hiding. I'm willing to sit at a table with the Conservatives and the NDP and the Bloc as a coalition. I'll sit with the Governor General. You put us at the table with somebody that actually cares about Canada.
So that, to me, again, undermined that central claim. And one last thing I'll share with you, and see if you caught this too, or if you shared my point of view, is that one of the police officers who was introduced as a witness, it was Russell Lucas. He was sort of this liaison officer dealing with the Auto Police Service's potential negotiations with the Freedom Convoy demonstrators. He said, while he was testifying, when asked by the defense, that there were no instances of violence from demonstrators towards police, and that emergency lanes remained open on the roads upon which Freedom Convoy vehicles were parked, with the exception of a small segment of Wellington. And lastly, the intro video that we saw on day one, that 11.5-minute video montage, didn't capture anything regarding violence from demonstrators towards police officers. So with that long-winded question out of the way, what do you think are the major takeaways, and what do you think of my assessment that the prosecution continually undermines its own case?
Well, Robert, that's very interesting. And from what you said, I'd say, the big question for me is, why is the Crown doing that? That's a question I've been asking myself throughout this trial. You mentioned their opening statement. Usually we get a bit of a roadmap with respect to where the Crown's going in their opening statement. I don't think we really got that from them. And then they started introducing evidence. And in some cases, as you've alluded to, it's not quite proper evidence yet because it's in a voir dire, and that's a trial within a trial, and the admissibility over that evidence will be determined later. But you look at it and you say, why this? Why is this part of their case? And we're not the only ones who are asking ourselves that question. Even the defense lawyers have these questions, right? There's, for example, there's a conspiracy which has been alleged between, we don't actually know. We don't know who was part of the conspiracy, but what the Crown is trying to do is to prove that a conspiracy exists and to prove that Lich and Barber were part of that conspiracy so they can use the evidence against each other. Now, it's a little bit more complicated than that, and if anybody's wondering about it, they can read about it at our webpage, the Democracy Fund. We've explained it in our daily updates. But, the defense lawyers don't know what the conspiracy is about. There's disclosure that they haven't seen yet. There's disclosure that they have seen, and they've asked the Crown Attorney, how do you intend to rely upon this? And they've had an answer, and now that answer has been expanded. So I think there are a lot of unknowns so far.
Okay, I want to press on this because you reminded me of something from the trial. So you mentioned the conspiracy aspect, and the Crown said that Tamara Lich and Chris Barber were involved with the conspiracy, and the judge then said, and I quote, with others. So literally there are others in the conspiracy that are literally not specified. That's strange. And also, if I recall correctly, I don't even think the specific alleged crimes were listed in the opening statement, unless I might have missed that. I don't even think the prosecution specified mischief or obstruction or what's the term, incitement or inducement or counseling, I think is the word they use. Counseling towards mischief or obstruction of police or intimidation. So I agree with you. There's not really, that's a great term you used. Roadmap was lacking. It's not even clear what they want to intend to do.
No, you're right. Now, to start off with the conspiracy, I think the judge doesn't know. Right? That's something the Crown is going to have to advise about by Monday morning, and I'll tell you they have a lot of work to do. But for this type of application, it's called a Carter application after the case that sort of set out the law. And the court has sort of clarified over the years that the conspiracy could just be two people. And there's a lot of sort of legal discussion about that and even some confusion about that, just because of the way the test sort of rolls out, but I won't get into that. Let me go to, I think the other thing you were saying here, which was about the charges. You're right. We haven't heard about the charges in court so far. The judge knows what they are because they're in a document called the information. But, I don't think a lot of people even in the mainstream media know what the charges are because I've never seen them listed in any mainstream publication. So Tamara Lich is in fact charged with 6 offenses. She's charged with mischief. She's charged with intimidation. She's charged with obstruction. And she's charged with counseling all those offenses, but counseling them not committed. That means that the Crown isn't actually alleging that anyone committed a crime because of what Tamara allegedly counseled.
I know we spoke about this on day 1 or day 2. It's almost reminiscent of that movie Minority Report. It's like this pre-crime thing. It's like she supposedly counts people, but the crime wasn't even committed. It's so weird in 1984 and thought crime style. Very strange. So one thing that I recall from the testimony of Russell Lucas, who, again, let's just give him his official title, I think, was something inspector or he was managing, again, the logistical response to the Freedom Convoy. And he said during his testimony that his discretion to negotiate with the Freedom Convoy was essentially suffocated, rescinded by some higher up that he was not sure who was. He speculated it was the police chief's office. And he said on the stand, if you recall, that he wanted to make some sort of negotiation overture to reduce, in his words, the footprint of the convoy in order to reduce a couple of things, reduce its geographical impact, reduce the impact of congestion on the city of Ottawa, and also to enhance the police service's capacity to maintain what he said was public safety, because the more consolidated and concentrated that actual vehicle footprint, the easier it is to manage logistically from a security perspective. Now, he said he was not able to do so because he was given this directive that, quote, not 1 inch be conceded to the Freedom Convoy in any endeavor, even if it came to the point that he was offering something in order to get a reduction of their footprint. We heard today, Marazzo was speaking back towards the end of the convoy during that press conference, and Marazzo was saying that he doesn't even think the police chief at that time had the ability to think for himself or to operate independently, that he used the word impossible position. And that sort of reinforced what I heard from Lucas, that the authorities themselves, at least those who supposedly had this ability to negotiate, were not able to do so because higher-ups prohibited them. Ottawa Police Chief, who himself, at the time, Peter Slowly, was subordinate to the city mayor. We saw every day on the news Justin Trudeau speaking about his involvement with relevant levels of governmental authority. So clearly Trudeau himself was stating that he was involved, or at least his office was involved in logistical organizations. So my speculation is that any sort of suffocation of the ability to negotiate with the Freedom Convoy, any sort of not 1 inch directive as we heard. Also, Marazzo in that testimony today, or sorry, that hearing said that the Ottawa authorities would not talk to the Freedom Convoy. He's like, we just want to sit down and talk and negotiate. They won't talk to us. To me, that seems to obviously come from the Prime Minister's office. I wonder if those sort of threads were weaved in your mind just as they were in mine. If you sort of made those connections in terms of a sort of centrally directed plan not to negotiate and in turn exacerbating the impact of the convoy, ostensibly the same problems the government sought to address or claimed it cared to reduce or mitigate.
Right. So we did see evidence from Lucas. That was direct evidence. He was called as a witness. And then there was a video in which Tamara Marzano was speaking. I think that's what you're referring to. And, and we did hear that evidence. It was very interesting evidence. It was perhaps the most interesting evidence of the week, that Lucas and others wanted to concentrate that protest for the reasons you said, right? Because it's better for the protesters, it's better for the city, it's better for police, but they were given the order. And, at first he didn't really specify where it came from, but I thought later it was quite clear it came from the chief of police.
Yep.
And that order was, as you say, not to give 1 inch to the protesters. And that meant don't allow any of those trucks onto Wellington. And if they had that discretion, the protest might have looked a little bit different.
Yep.
Right. And police discretion, it's really important, I think, because they're the ones on the ground, right? And if you handcuff them, if somebody up in an office is handcuffing them, how are they supposed to do their job? I don't want to go too far into this, Robert, but I think, police discretion is actually, it is one of the most fundamental parts of our legal system. Without police discretion, we wouldn't have the right to protest, because almost all protests break some law or another. But police look at these protests and they say, well, there's a law being broken there, but there's a right to expression, there's freedom of assembly. It's just not in the public interest to try and shut this down with a bylaw. They don't do anything about it. That's how our system works. They need it.
This is such a great point. I'm so glad you made it, that police discretion is important. More fundamentally, we're overly centralized and concentrated in so many ways. I'm so glad you said that. And I loved that you described it as being handcuffed, no pun intended. So the last question I'll ask you is just your overall impression of the judge's assessments and interjections. From what I observed, she seems to be a little bit frustrated with some of the things the prosecution's been doing. For example, today, with the prosecution seeking to refine some of the aggregate evidence it initially submitted, something like 4,000 pages, if I recall correctly, of encrypted chats that were obtained from presumably Barber's and Lich's mobile devices. Now they want to, narrow that a bit. We want to use 2,000 pages, but that's being done mid-trial. And the judge said, this is a quote, she said this at least 3 times, that she is very upset with the prosecution's attempt to make this refinement, make this narrowing at this point of the trial. And she said that she wishes it would have been done by August 1st to allow for adequate time in her mind for the defense to engage in preparation in the context of disclosure. There were other moments in the past few days where the judge seemed a little bit displeased with some of the conduct of the prosecution. I wonder if any of that sort of resonated with you, if that speaks to something larger or anything you might want to share regarding what I'm saying.
Well, I can't say how the judge feels. I don't know that. I know she is certainly insisting that the legal rules of evidence be followed very carefully. One thing we have in our justice system is limited resources. We talk about it as a world-class justice system, but we do have limited resources. And one of the biggest limits we have are dates that are available for trials. And when trial time is not being used well, for whatever reason, it could be somebody's fault or it could be inadvertent, but judges don't like that, especially in the criminal system, right? Because you have people in jail waiting to go to trial. And so, the judge could be unhappy for that reason alone.
This is such a great point. I'll just close with my own observation here. We watched some videos today that are seemingly completely irrelevant. These 30-second TikTok videos of Tamara Lich saying this or that. Again, maybe the prosecution will weave into some sort of cohesive narrative, but to your point, I think it's great to emphasize that negligent prosecution, again, deliberately or otherwise, however it came about, ends up consuming resources and leaving people in jail and mitigates their ability to a speedy trial, let's say.
I would say that's true. I wouldn't say that these prosecutors have been negligent. I don't think that. I'm not saying that, but generally as a point, and mistakes that any lawyer makes.
Fair.
And mistakes happen in trials. They're really unpredictable, right? But they do that. And just to your last point, Robert, your question about, well, how are these videos relevant?
Yeah.
To me, again, that's the big takeaway. It's a big question mark. That's how I see the first week of trial.
Same. Well, to be continued. Oh, thank you.
Thanks.
So just before we sign off and end this talk, I want to invite the Rebel News audience to stay up to date with our reporting on the ground. Go to tamaratrial.com. And for those of you that would like to assist Tamara Lich with her legal defense fund, please go to helptamara.com.